We want to welcome all of our visitors that we have here today, and for the record, the board would like to extend its condolence to our executive director, Ms. Vess, on the loss of her granddaughter.
Balance. I'm going to do roll call. Keith Harvey.
Here.
Scott Cockcroft.
Here.
Karen Jones.
Here.
Vivian Hickson.
Here.
And Ken Roberts.
Here.
For the record, all board members are present. We do have a quorum. The first item on your agenda is the agenda.
Have the members had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
So move.
Second.
Okay, we have a motion and a second to adopt today's agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. And the next thing on the agenda is the minutes from the June 19th, 2014 board meeting. Have members had an opportunity to review those minutes?
Make a motion to accept the minutes as passed.
Second.
We have a motion and a second to approve the minutes from that meeting as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion passes. And the next thing is the election of the officers.
That's right. We're ready. We're all here today. We've postponed it twice. So let's start out with calling for nominations for board chair.
I would like to nominate Vivian Hickson to continue as our board chairman.
Do we have a second to that nomination? Have any other nominations? Vote to approve by acclamation.
I'll make a motion that we close the nominations for chairperson and that we elect Vivian Hickson by acclamation.
Everybody have to vote? All in favor?
Aye.
Any opposed? And now we're accepting nominations for vice chair.
Make a motion for Mackenzie Roberts to remain as the board co-chair.
Second.
We have a motion and a second. Do we have any other nominations? Okay, motion to. All in favor, voice by saying aye.
Aye.
Now we'll vote on Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? We did the first for acclamation, but we closed the nomination. It was a little bit
Now we're
confusing, but
taking
we got there.
nominations for secretary. And no, you don't have to do the minutes and you don't, it's just part of your law, so. Nominations for secretary.
I make a nomination that we continue Karen Jones as our secretary.
Second.
Do we have any other nominations? Okay. All in favor, voice to close the nomination through.
Make a motion that we close the nominations and that we elect Karen Jones as secretary by acclamation.
Thank you.
That's what I should have seconded, but I'll second that.
That's okay, we're there now. So you're seconding Mr. Roberts' motion?
Yes.
All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
The next item on your agenda is your legal report, and I would like to introduce Ed Scudder. Mr. Scudder is Assistant General Counsel, and he will be taking over as your staff attorney. Josh is moving to the Board for Licensing Contractors. He's gonna stay and help for a while, but we're gonna miss him. And we wanna welcome Ed.
Welcome.
Thank you. I know I've got some big shoes to fill. Everybody around here sings Josh's praises. He's helped me along. He's been
Josh, you gonna do our legal report one last time?
Yes, ma'am.
Okay.
And I just want to say that it has been a pleasure serving as your board attorney. And I feel like I leave you in capable hands with Mr. Scudder. First matter on the legal report is case number 2014-0008851. Complaint was established when the board office received company renewal form that failed to list all previously active registered employees, as one employee was missing and no termination notice had been received for the employee in question. Respondent DQA stated that the termination notice for the employee in question had been mailed within the 30-day time period allowed by rule and referred to a FedEx tracking number, which, when looked up, noted that the package had been delivered on 3/17/14, which, if true, means that it was properly received within the 30-day period of the termination. My recommendation is therefore close.
Madam Chairman, I make a motion that we concur with the recommendation of a council and close this particular complaint.
We have a motion by Mr. Roberts. Do we have a second?
Second.
Second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2 is 2014-011141. Consumer complaint alleges respondent failed to terminate their contract despite the complainant selling their home and wanting to terminate service. Consumer also filed a Better Business Bureau complaint against respondent. The BBB complaint file, or a portion thereof, was attached in respondent's answer to the complaint. The BBB file, which shows history of the complaint, seems to indicate that complainant failed to submit termination request in writing within the time period set out in the contract, and that respondent offered to credit their account if they maintained their service at their new address, but told them the process to follow to terminate and advised that they would owe the summary of their balance on the remaining bill. Complainant is upset that they kept debiting their account after a phone call was placed, telling respondent they wanted to cancel and that they would now owe the remaining balance since they did not want to maintain service at their new address. My recommendation is that we close this complaint.
Make a motion, we concur with council on this matter.
I'll second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones to concur with their council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-011101. Complaint was established when employee application was received listing the hire date more than 30 days prior to receipt of same. Respondent states that the employee in question was not hired until 4/1/2014, as he was a temporary worker employed through a temp agency where he was not privy to any sensitive customer information. Respondent therefore timely submitted the form, just listed the incorrect hire date on the form. My recommendation is we issue letter of instruction regarding filling out the registration application with the date hired in registered position rather than the date hired to do other work not requiring registration.
Make a motion, we concur with council.
Second.
And a second by Mr. Roberts to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-011571 and 2. Complaint was opened after respondent here filed a complaint against another licensed alarm systems contractor company, alleging they were doing business under his QA license despite him terminating his employment there. Investigation was conducted in that matter, which failed to substantiate the claims made, but did reveal that respondent had engaged in a contract under an unlicensed alarm contracting company that he ran for a short time. And respondent here did not want to talk to our investigator about this matter further, as he felt it would incriminate him. Copies of contract agreements between respondent and the company he's subcontracted with were obtained from the properly licensed contract security company. My recommendation is to authorize formal and send a consent order with a civil penalty in the amount of $500 to each respondent, which would be $500 to the contracting company for not having a valid license, and to the respondent QA for operating as the unlicensed alarm system contractor.
For the two respondents, it's the
It's the QA and the company. This stems from a previous complaint where this respondent here had filed a complaint against the company he was formerly employed with as their QA, at which time he terminated his services as their QA and went out and essentially subcontracted with his former employer without having his own company license.
So respondent 1 is the company and respondent 2 is the QA? Okay.
Madam Chairman, I make a motion we concur with the recommendation of council.
Okay. Motion by Mr. Roberts and second by Mr. Scott. Approve, to agree with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed?
Case number 2014-010771. Complaint was established after company renewal was received, which listed one employee for renewal whom had been previously listed on a termination notice sent to the board office. Respondent stated that they had pulled the employee in question from doing alarm work and had her working in other areas, but had thought that they kept her alarm registration active. My recommendation is issue letter of warning regarding properly registering all employees per TCA 6232-312A.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-008881. Complaint was established when company renewal notice was received, but no listing was found for one active employee, and no money was sent to renew employee's registration. No termination notice was ever received on the employee in question. Respondent failed to respond to the open complaint in writing within the time frame allowed by rule. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $200 for failing to list all persons required to be licensed per TCA 6232-317D, and an additional $100 for failing to timely respond to an open complaint in writing.
Josh, that would be then a total of $300.
where do we come up with the $200? Is it based on months or the?
No, I apologize. I think that I realize it's confusing the way that that's written. I think that it would be a total of 200.
That would be more consistent with what?
Yeah,
the
I mean, it would
$100
be,
for-
you're correct. It would be $100 for the one employee not registered, and then $100 for not responding.
Yeah, just trying to make sure we understood what the recommendation was. It
Well,
was-
as I read it, I understood that it was confusing.
It's a total of $200.
Yes, ma'am.
Madam Chairman, I make a motion we concur with the recommendation of council, authorize a formal hearing and send a consent order with civil penalty in the amount totaling $200.
Okay.
Second.
We have a motion by Mr. Roberts, the second by Ms. Jones to concur with our council's recommendation as read into the record. All in favor, voice by saying aye.
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 All opposed? Motion carries.
Case number 2014-008861. Complaint was established when renewal notice was received that failed to list 3 employees that were previously registered and for whom no termination notices had been received. Respondent states this was an oversight on their part, as they were not aware that the registration themselves, or as the registration themselves have no expiration date, and they are to list and pay the $75 per employee fee on their company renewal. My recommendation here is issue a letter of warning regarding properly listing all employees on the renewal.
What would be the difference in this one and the last one? Just the fact that they didn't, the other one didn't respond?
Right. I think on the current one that we're discussing, they actually did subsequently pay the registration or renewal fees, and they did respond. And I mean, they've cured what
They did renew, whereas the others was
the other one
actually-
just
was a
didn't-
termination.
Right.
Okay.
The other person never responded and never paid any money to renew the individual.
I would make a motion to concur with our recommendations from staff.
Okay, we have a motion and a second to concur with their council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-017241. Anonymous complaint was received stating that one employee had been working for respondent for a period of 2 months as of 6/6/14 without being properly registered with the board. Respondent provided what was termed the employee's first pay stub and her W-4 form, which indicated she had been employed since 5/19/14, with the W-4 bearing that date as well. A note in the employee's file in the RBS system also indicated she was transferred to respondent effective 5/19/14. Therefore, there is no evidence to substantiate the complaint. Our recommendation is to close.
Motion to concur with council's recommendation.
Second.
Second by Mr. Roberts to concur with their council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-008821. Complaint was established when 5 employee termination notices were received by the board office on 4/8/14. Termination date for 3 employees was 1/2/2013. The other 2 termination notices had dates listed which were 8/15/12 and 7/12/13. Respondent states that he understands the failure to submit the termination notices in a timely manner is his responsibility, but states that the company underwent a lot of changes and the owner, who was old and ill, told him that she had properly submitted notices, but it was later that he discovered after her death that she had not. A former employee of the same company who worked with the respondent also sent in a letter supporting respondent's statements regarding the owner's health and her errors to timely do things that she had indicated to respondent and the employee that she had done, when in fact she had not. Our recommendation is authorize formal and send a consent order with a civil penalty in the amount of $125, which would be $25 times 5 late termination notices. I believe that would normally be a $50 per late notice penalty, but taking these circumstances into account.
Josh, do you have any indication of what the respondent's position was with regards to this company?
He was the QA.
He was the QA, okay.
It was just, it seems like in this case it was a smaller company, and the woman who had since passed away just did things the way she did them, and had indicated that she had submitted forms and done all the proper paperwork when they discovered afterwards, when they were getting the affairs in order, that she had not.
So basically, the QA found a discrepancy and was
sent in the
taking
notices.
steps to rectify it.
Right. Yes, sir.
And they've also, I mean, they've put the actual termination dates, it appears, so they
Madam Chairman, I make a motion we send a letter of warning to this, to the QA concerning the timely submission of termination notices.
Okay, we have a motion and a second to alter our council's recommendation to send a letter of warning to this. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-011121. Complaint was established when it was noted by board office that respondent company had been without a DQA since 1/14/14 without providing notice of DQA's termination or subsequent replacement of their DQA. It appears respondent is still operating without a DQA in violation of the Alarm Act, and all correspondence sent to the address on file has been returned unclaimed. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $8,350, which would be $250 for failing to notify of the DQA ceasing duties within 10 days, and $750 times 5 months of operating without a DQA, and $750 times 5 months of operating in invalid status, and additional $500 for failing to replace DQA within 30 days or request an extension, and $100 for failing to timely respond to the complaint in writing. We haven't received notice that they aren't open, and every indication is that they are.
It says-
We're concerned it's a valid company, they're just not complying.
Right.
We send out notices certified or something where they've got to sign for it. Not like their regular mail is coming back returned. Is that right?
Yeah. Do we send those out both?
We do the invalid letters, certified mail, before we ever give it to
Right.
you, and I don't.
I think they send the.
They might just not
the
be signing
complaint's sent
for it.
out-
Right.
The complaint's sent out by certified mail also.
Right.
so.
Yeah.
It's not like their regular mail's getting returned to us as though they're not there. They
Not that
may
I'm
just
aware
not be
of.
signing for it.
Yeah.
Right.
I was wondering the same thing, if were they a real company or not, but it sounds like they could still be there and just not.
I think they do other things besides alarms.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
We have a motion by Mr. Roberts, and a second by Mr. Harvey to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2014-010761 and 2. Complaint was established when a telephone solicitor, respondent number 2, called a state-issued cell phone that belonged to one of the investigators for Commerce and Insurance. The investigator allowed the phone solicitor to go on and identified that the solicitor would give her a, quote, free wireless alarm system for $54.99 a month for monitoring via respondent number 1. Respondent 2 states that they do not do business outside of California and do not engage in business with respondent number 1. Respondent number 1 states that they have no authorized dealers or any dealings with a company operating under respondent number 2's name. The only indication that respondent number 1 is engaging in unlicensed activity is the investigator's trace of the phone number to a physical location in Bakersfield, California that is linked to respondent number 1. Also, as the board is aware, there is an exclusion in the rules regarding telemarketers under Rule 0090-01.03, subsection 8, that states telemarketers are excluded if they do not have access to confidential customer information regarding existing or proposed alarm systems. Based on the evidence that we have, my recommendation is to close as to both respondents.
I wouldn't think that the telemarketing exclusion would apply if they were actually doing business, but it doesn't sound like they're they're claiming they don't do business in Tennessee, but why were they calling a Tennessee number? Telemarketer altogether, I mean, they couldn't be selling alarms telemarketing, but I would think that typically would be tied to an alarm company. We wouldn't be,
As an advertisement.
well, that if someone had telemarketers in their licensed alarm company, those telemarketers don't have to be registered. Doesn't sound like we really know what, do we know what company?
Well, here, the licensed alarm company says that they don't do any business with the unlicensed company from California. And there's not any other evidence other than the fact that they made a phone call and were soliciting, but they, there's not real, there's a, not even a tenuous link between,
I'm inclined to agree that we would close. It just doesn't, I don't think that typically though, the exclusion for telemarketing would necessarily apply, but it's,
it depends on, I mean, I agree. I think it depends on the facts. I was just pointing out that here, if they were soliciting on behalf, which the licensed company says they aren't, but if they were, I think that they might fall under that exclusion. But here, the evidence is there's a phone number originating from California, but respondent denies that they do any business outside of California. And other than that one phone call,
I wish it was something else we could do to slow down the highly irritating practice of unsolicited phone calls from out-of-state companies that aren't authorized to do business they're soliciting for, which appears to be the case. But I feel like, given the circumstances, probably our only realistic course of action is to close this, as our council has recommended. So I would
that or send a letter of warning.
I just make a motion, we go ahead and close it as Josh has recommended.
We have a motion to concur with our council's recommendation. Do we have a second?
Second.
And a second. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-01-7711 and 2. Got one respondent. Yeah. For some reason, I only see one respondent, but it's one respondent, but they have 2 locations, so I guess we opened 2 complaints. Okay. This is established against 2 locations for an unlicensed company. They actually advertise themselves as a locksmith company, which they are also not licensed to do, and we're dealing with that in the locksmith program. This complaint was established when it was discovered that respondent here had been advertising for alarm systems and CCTV installations on its website. Respondent admits that it was advertising, but they had performed no services involving alarms or CCTV sales or installations, as they are primarily an unlicensed locksmith company. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $1,000 for holding itself out as an alarm systems contractor company without a valid license. For tracking purposes, since this was opened against 2 different locations, but it is the same business owned by the same gentleman who I've spoken with on the phone, I think it'd be best if we divide it into $500 to each against each respondent here, as there are 2 respondents.
Each location is what you're saying.
Right,
then.
yes, sir.
Yeah.
So it'd be $500 to each location.
Totaling $1,000.
But it's the same company holding out a shingle under 2 different professions.
Yes,
And
that's
each
correct.
profession has a $1,000 fine for unlicensed activity.
Right. but I think here it'd be 500 because it's the same respondent, but it's
That's
going to
what I
total
meant.
1,000 in the end.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
We have a motion and a second to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed?
Opposed?
Okay, let the record show we have four and one against. Motion does carry.
Case number 2014-015991. Complaint was received from a consumer alleging that Respondent Monitoring Company, buying through a door-to-door salesman, employed high-pressure sales tactics and misleading information to sell complainant on a new contract. The salesman became agitated when complainant refused to allow him into her home. Respondent states that this representative was not employed by them, but by one of their authorized dealers. Respondent states that this type of behavior is not condoned by them, and they have forwarded the complaint to the authorized dealer for response. Complainant states that the sales rep who came to her door wore a shirt with only respondent's name and logo on it, along with one other well-established alarm equipment manufacturer. This in and of itself seems to be misleading, as the board is receiving more and more of these types of complaints. The authorized dealers do not identify themselves clearly and appear to be implicitly allowed by respondent to represent themselves as representatives of respondent alone and not that of the authorized dealer, which is the cause of much consumer confusion. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $2,000 to the authorized dealer for improper and dishonest dealing and misconduct in violation of TCA 6232-319D, and for holding themselves out as doing business under a name other than the one under which they are certified to operate per TCA 6232-316E, and issue a letter of warning to Respondent Monitoring Company regarding TCA 6232-319D concerning misconduct and dishonest sales practices. While Respondent may not be directly engaged, they are still complacent in allowing authorized dealers to continue this deceptive sales practice.
Madam Chairman, I make a motion we concur with the recommendation of council, and in doing so, I commend our council for taking an action both against the authorized dealer and the respondent monitoring company. I think it's highly appropriate and given the circumstances.
I second and agree.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to concur with our council's recommendation.
This is against, or this is strictly for the dealer, not the,
Well, Scott, it would be, the penalty would be authorized against the authorized dealer or the local company, presumably. I'm assuming it's a local company. The letter of warning would go to the monitoring company, which could be somewhere way far away. So I think in doing this, we're putting the monitoring company, which actually appears to be referred to here as the respondent monitoring company, kind of putting them on notice that that this sort of action is highly discouraged.
Now, I would point out to the board that this isn't the first time that we've had these same respondents involved. However, in the past, I believe, due to whatever evidence we had before us in those matters, it was closed or a letter of warning was issued, but we continue to see the same individuals and the same types of practices. I mean, essentially, this is the template for the same types of complaints that we are getting more and more of, and Ed will be presenting some at the next meeting, most likely, that involve different, some of them might be the same companies, but I believe that there's other companies operating in much the same fashion.
and I don't doubt that there may be a number of authorized dealers that do that. I would just question whether or not, and I don't know, I mean, y'all may have a better feel, how sincerely the the original respondent in this, that they may be condoning, whether they're actually condoning this or not. I mean, they may be trying to get that to stop. I guess they could quit dealing with those dealers if they were continuing to get the. I agree with the motion and what we've, but yeah, I just wanted to make sure we were talking about it against the authorized dealer and not. We can see that there is a concerted effort on their part to condone it.
That you're putting them on notice
Right.
will cause them to pay closer attention. We have a motion, Mr. Roberts, a second by Mr. Harvey, I believe it was, to concur with their council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
I only have one case for representment today. Case number 2014-002171. The board originally authorized a consent order with civil penalty for $150 when no response was received to a complaint in writing, and the violation was the termination notice not received within the 30-day time period. Respondent here has adamantly contended that the termination notice was sent within the 30-day time period and provided a document with handwritten, mailed on date note on what appears to be a copy of the termination notice. Respondent further contends that they had received no knowledge of the complaint itself until the consent order. The consent order was sent to the same address as the original complaint. However, complaint was returned unclaimed. Respondent has asked that the board waive the $150 civil penalty in this instance. And I would note that this respondent has been licensed since 2005 without any disciplinary action. And
So they did not claim the complaint letter, but they did claim.
that's their story.
They're saying that they didn't say they didn't claim it. They're saying they didn't receive it. And stating, they're saying they had no idea until they got the consent order.
Madam Chairman, I make a motion we concur with the recommendation of our council and we close this particular complaint.
Okay, we have a motion and a second to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Thank you. I believe that's it. Did you have anything? No. Okay. Thank you.
Thank you. Will you be doing our rules making?
Yes, ma'am. It'll be October 16th, and I should be present for that. I believe my chief counsel, Tony Glandorf, would like to address the board, if that's okay.
Certainly.
Good morning.
Good morning.
Board members, my name is Tony Glandorf. I'm the chief counsel for the regulatory boards. Apologize, I could not have been here earlier to address you all and introduce. I have been appointed as the chief counsel as of, I believe, 4 weeks ago. I was the board attorney for the Motor Vehicle Commission. I don't believe I've ever had the opportunity to come before you all and meet you all. I'm probably a new face. 5 years with the department, and boss is Michael Driver. He is our new deputy general counsel. I'm not sure if you all. To come before you all and let you know that there have been some changes in the structure and our legal department. Very much committed to providing the best legal guidance that we can to your board and providing you with the best product that we can. A little bit about myself. I received my law Josh has done an excellent job from what I've seen over the past few years. From your program to put him on a contractors board. That is that the contractors board, their attorney, Ben McDonough, up in his career, which left a space open for us, and it is very difficult to he has a background in these types of programs, and we're really make the commitment to you all right now, but I'm here to assist Ed. Do you have any questions of me?
Thank you.
Okay, I believe next on our agenda is the administrative report, and the first is the open complaint report.
Are we ready to go, or do we want to take about a 5-10 minute break? It's up to you guys.
Take a break.
Okay.
Take a 10-minute recess. Somebody said they're gonna take a break. It's probably just.
Thank you, dear.
Josh, we're gonna miss you. You've done a good job here.
Hey, I
appreciate that.
Process,
last
just when
month.
we finally get you educated.
I know.
I know.
Can you believe we
I know.
got him in?
The meeting of the Alarm Systems Contractors Board is going to be back in business. I think the next thing on our agenda is the complaint folder.
Open complaint report.
Yes, ma'am.
I would like y'all to bear with me. I'm used to sitting here taking notes, so we'll get it. All right, the first item is Exhibit B. It's your open complaint report. We had 41 open complaints before the 13 or 14 we heard earlier today. Some of those had 2 respondents, so that will probably bring our count down to under 30. Now, again, I think we open about as many as we close in a month's time, so. But right now, I know our complaints are looking a whole lot better than they did even 6 months ago, so I think we're in good shape. Do y'all have any questions? All right, the next item on your agenda is the disciplinary report. I don't think I can. So, I got those in the wrong order when I scanned them yesterday. If you'll notice, August is the first thing in your packets. For August, we brought in $25,200 in civil penalties. These are posted on the department's website every month. I'm just gonna scroll through these. I think the first one on there, the $20,000, that was done by a payment plan. I think they paid it $5,000 a time, and it's paid off. So, but that brought our income from that up considerably.
So the people on this report, they've signed the consent
They
order.
have signed
and
and paid. Okay. Now the next month in here is, and again, you can look at these on our website. It's posted every month. The next month in your report is going to be June, where we brought in $2,700, and those are the respondents. Have y'all found it on your iPads?
Yeah, I
excuse
was telling him you can sign up. I noticed on the website you can sign up to have the disciplinary report sent to you each month when
I
it comes
send it
out.
to you every month by email for our boards, but
Yeah.
you can look at all the programs
Right.
on the website. All right, that was 2,700. The next month on your report is going to be July. And if y'all notice on June, this is how many people were suspended for child support in June. We did have a couple of alarm people, I think, back here. That was just June child support suspensions from DHS.
Private guard service.
It goes on for days. Now, a lot of those have since been put back in compliance because they got their child support caught up, but that's also reported as disciplinary action. So, all right, the next month on your report's going to be July. For July, we have $2,200 in civil penalties. These are the respondents. And for a total for 3 months in civil penalties, $30,100. Again, that is considered income. You can't count it as part of your budget for income purposes, but it is income for the board. Anybody have any questions about the disciplinary report? Next thing on the agenda is, and I'm not real sure we need to look at this right now because I send these to you every month. It's the monthly report, which tells us how many open applications we have, how many applications were denied. Have y'all had an opportunity to review those when I send them? Do you want to look at them further for any reason? I mean, just from the count here on the applications received and approved, and then the applications denied. So, again, that is sent to y'all on a monthly basis. So, all right, Exhibit E is legislative report. We have had no legislation reported since the last meeting, so your exhibit in there just says there's no new legislation. All right. Exhibit F is your budget update. There's been no change since the last reporting at the board meeting in June. I just did a recap of that, so you can see that our revenue is $641,390.83. Our expenditures are $310,930.65. However, we still do not have the departmental cost backs, so we don't have the administrative staff salaries or the other departmental cost backs. So once we get that final reporting, Cody will be bringing that to you at the next meeting. Okay. Exhibit G is a discussion on the apprenticeships. At the last meeting, we showed you the legislation. It was Public Chapter 881 regarding the apprenticeship, and the legislature, they would like for every program to have an apprenticeship program. I'm going to let Josh and Ed kind of address this as far as your position.
They want every program to go through and basically evaluate if they don't have an apprenticeship program, or if they have had one in the past, what did it look like, and if they have never had one, what would the apprenticeship program basically look like. And Ed and I are going to work on that and draft, basically go through the checklist and draft something for the board to review. And during your review, you can either adopt that as your position, because as the board knows, we already have employee registrations where they just get registered after 30 days and they have a year to get their training. So, I don't know what the board feels about that, but I think we discussed this briefly when Cody was here at the last meeting, and we didn't really know. It might be more burdensome to create an apprenticeship for that type scenario than it are. I mean, we've already got this in place. It seems to be working. So that's something that is going to have to be done by the end of the year, by December, I believe, is our deadline. So by the next meeting, we'll have something drafted for the board to look at as far as proposed findings regarding the apprenticeship program, and we'll present it to you all, and we can discuss and make any changes that you all see and have discussion about it at that time.
Josh, the Electronic Security Association has a formal apprenticeship program available. I don't know whether you've had a chance to take a look at that or not. I'm sure Penny Brooks could provide an overview or the details of that. It's a very formal apprentice program that was developed across a number of states, and it's just formal apprentice program. And in some states, the idea of an apprenticeship is a really important thing, especially in areas that are very highly unionized. The apprenticeship program is a very important part of what they do. So the Electronic Security Association has developed such a program. I would suggest that you get a copy of that and look into it. I think really what we're doing is probably reasonable for our particular situation, but that could provide some additional insights that would put together, like I say, you really don't want to reinvent the wheel if there's an effective program that's available just available to be used.
Right. And I do remember you mentioning that last time, and I will research that further, and we'll look at it prior to the next meeting.
And I believe that program is available to, you don't have to be a member of the association. I'm not positive about that, but I don't believe you have to be a member of the association to be able to take advantage of most of the benefits of that particular program that's already established.
And an apprenticeship program would be good in some ways. A lot of government contracts require that are prevailing wage. You aren't able to employ some people unless they were in an apprentice type program. It would allow some kind.
The next item on your agenda is Exhibit H. It's a request from Stanley Security Solutions, Memphis office, for a third extension to replace their designated qualifying agent. They do have an applicant on file. I put this in your packets. The first applicant they had in March, the board denied his experience to meet the requirements. So they had to find another one. And they do have another one. And the only thing that's pending is payment of the $50 license fee and receipt of his TBI, FBI background check. It was sent out August the 28th, so we should be getting that. But their current extension expires September the 19th. So they've been very compliant with requesting and notifying us as required by the law. So
They're good on everything else. There's no other problems with.
do we have
Madam Chairman, I make a motion that we grant 30-day extension as requested.
Okay.
Second.
Okay, we have a motion and a second to grant this company its third extension for QA or DQA. All in favor voice by saying aye.
Aye.
All opposed? Motion carries.
The next item on your agenda is an appearance at 11. I think we're a little bit ahead of ourselves today. She's not here yet. So we're going to move on to Exhibit J1. Exhibit J1 is alarm qualifying agent experience. We have William Matthew Holmes application. There's quite a bit of information in that exhibit. He's been registered as an alarm employee since 2011. However, in 2011, he also had a complaint filed for unlicensed activity. And if you will read the legal report, he was very cooperative with legal and paid a civil penalty for the unlicensed activity. Where I don't have enough experience to show that he's had exactly 5 years, you have in the past approved people based on the fact that they had other experience outside of being registered. So he does own his own company and he wants to be his own qualifying agent. Based on the information I have, he was with that company from January of 2010 till now. He also had some other experience with the police department putting in their camera systems when he was a departmental employee. And is requesting your approval. So. He only has a CCTV license. That's all he does.
At this point, he's not taken the tests or other things, or has he?
He's had his CCTV training. He had that last year. All he needs to do at this point is take the exam.
Feel like he has the experience,
Well,
just
again-
that it's not documented, or, I mean, as far as with the,
He initially started his own company doing just CCTV installations in 2008. And then when he found out a license was required, he ceased and then got licensed and got registered. He actually applied for registration initially in 2010. But if you read through the complaint information, there's a statement in here from Andrew that the respondent from the beginning of this complaint has been extremely cooperative with legal, and also stated he pretty much admitted everything he'd done and paid the civil penalty. So you have done that in the past for people that have been disciplined for.
If I understand this, he's only short, is technically only short a few months' experience anyway.
Right.
And what you have presented is that he has had some experience with closed circuit TV while he was an employee, I would assume, with the Smithville Police Department.
That is correct. Again, he worked from 2008 to 2010, not knowing he needed a license because he was only doing camera systems, and at least that's what the complaint refers to.
His company is licensed, correct?
Yes,
They need to get
they
the-
have been. No, he just wants to become his own qualifying agent. He has a qualifying.
Doesn't have a license number on
Needs
his
to get
letterhead.
Paperwork up to par.
You might have a point there. He does not.
He's wanting us to review his previous experience, give him credit so he can become his own his own
Right.
QA for his company.
Yes.
He's had a QA, but he wants to become the company QA. Okay.
Make a motion that we accept the presented experience for our qualifying agent license.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Roberts to grant this applicant's request for prior experience towards his QA. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
The next item on your agenda is Exhibit J2. This is also an alarm qualifying agent applicant, Robin Jones. She's with Columbia Fire Equipment Company. She would like to qualify using her degree, and if you look at the very back of your exhibit, I put the new law which passed it's been about a year and a half since the statute was amended to include the degrees in electrical engineering, industrial technology, computer engineering, or in industrial engineering with 2 years of experience. And even though her diploma says she got a bachelor in business administration, if you look at her transcript, her major was information systems, which is computers. And I've looked through all of her credits, which are quite broad, but the majority of it, or quite a bit of it, is computer related.
What is this to be a QA for? Is it,
She's applied in fire only. She'll have to have the fire training and pass the fire exam.
I thought in the past we had done the information systems for monitoring. Would that be, does the statute say, or is it applicable?
The statute's in there if you can read it.
Would it apply for fire or anything?
It doesn't. Your laws don't designate qualifications based on classifications at all. So if she applied in fire today and wanted to come back and add CCTV a month from now, so again, it is not a degree in computer engineering.
Doesn't have any kind of alarm background periods.
She's been an
Much.
employee with Columbia Fire Equipment since 2010 or 11. So she's got quite a bit of experience. But for her to qualify to become a qualifying agent, she either has to have a degree. This is the second time she's applied, so
An installer or a salesperson?
she does both. From speaking with her, she does both.
Her degree seems to be more business administration. I think she's taken a couple of computer classes, but from what
Well,
I
if you
can
look at her
see-
major on the transcript, it was information systems and business administration. It's just, when they added all those new degrees, they're kind of vague as far as,
The classes don't have much to do, they don't have much to do with,
Safety.
again, it wasn't something that we
That's
could
what I'm
accept
concerned
in-house,
with.
so. Please talk on the record, okay?
And I think my concern is in installing fire alarms in particular is a very, very technical area. And from what I see here, I just don't see enough of what I would consider a technical background to support that sort of very, very important life safety application. I just don't see it here. Now, I realize the law expanded to recognize a variety of different degrees, but it's also incumbent upon us to try and evaluate a applicant's adequacy or potential adequacy in a particular area, and I just don't see that here. Now that I wouldn't want to close the door towards an appearance of some sort where she could explain that, but based on the record here, I just don't see that that her educational background is up to the standards that we really need to hold to in this probably one of the most technical of our alarm areas.
Why you have it on your agenda, so, again, we can ask her to come in at the next meeting. Or I can send her a letter and just indicate it's not acceptable at this time.
From what I see, I would not consider it acceptable.
There's just a, I mean, we
I
could ask
agree.
just a few questions in a personal appearance and find out whether she knows anything about fire or not.
Why don't we vote to not approve it, and then if she wants to appeal it, she can come in.
I'm gonna second Ken's motion.
I think the way Vivian stated it, that we deny her application based on the experience that we recognize. And of course, in doing so, we would recognize that she could appeal that, and if she chose to do so.
And the board would hear her then.
Yeah.
Okay. We have a motion and a second to deny, but with the provision of an appeal and a board appearance. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Okay.
All right, I guess we'll move on into Exhibit K, which is your alarm employee application review. And again, I apologize, I haven't looked at these as closely as I would have normally. I've looked at them. There's a couple in here I had a couple of questions about. Exhibit K1 is employee Bettis,
Oh.
file number 30876. Page 2 of your exhibit kind of details what he disclosed and what he had a 1996 charge in Bolivar, Tennessee for simple possession. 2001 reckless endangerment, which was from a DUI, I believe. 96 simple possession. He pled guilty. Hardeman County couldn't locate any records on this individual for those charges. He disclosed everything on his application. So the only convictions that are on here that I can see are the simple possessions. No, I mean, you need to ask. You look at the statement from Hardeman County, it says a search of their computer records since 1992 only shows 2 traffic tickets.
This is an application for simple registration as
These are
alarm
all
employee.
employee registration applications.
Madam Chairman, I make a motion we grant this application for registration.
Second.
Okay, we have a motion and a second to accept this employee application for registration on Mr. Bettis. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
The next item on your agenda is Exhibit K2, file number 30382. There is a 2013 charge that is still in effect. And if you'll notice, there were a couple of things that I'm not entirely sure he disclosed.
Time from 2013 is probation.
Yes, sir. Yes, sir. And that was fairly recent, so.
Personally not be comfortable granting a license to anyone currently under.
Madam Chairman, I make a motion that we deny this application.
Based on,
Well, for one, failure to disclose the assault with domestic bodily injury in 2012, if I'm reading that correctly, or maybe that's 2011, and
would this be denied based on a material misstatement or denied based on prima facie evidence of poor?
prima
moral-
facie evidence of poor moral character.
Okay.
Thank you.
Okay, we have a motion by Mr. Roberts. Do we have a second?
Second.
Second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? Application is denied.
All right, the next item is K3. File number 31228. Make sure, I think I put the wrong name here, but it is this person's file. There was a 1984 charge. Actually, two 1984 charges and one in 1985.
Motion that we grant Mr. Cafferty's employee alarm registration.
We have a motion. Do we have a second?
Second.
Okay, and a second. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Next item is Exhibit K4. File number 31416. ...2002 charge he printed on his application was actually a juvenile offense, and it's not on his record. So he really only has the one 2006 charge.
Madam Chairman, I make a motion we grant this application for registered employee.
Second.
Okay, we have a motion and a second to grant this application for registered employee. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
The next exhibit is K5, file number 31610. The only conviction on record was in 2006 in Millington, Tennessee. He disclosed another charge that has been expunged.
...2013 was expunged.
Yes. You have a copy of a signed expungement order in there. Even though he disclosed it, it's been expunged. So can't consider it. It's not a conviction. The only thing you can consider is the 2006 charge, and he pled guilty in Millington. There is a letter from his qualifying agent.
Madam Chairman, I make a motion we grant this application for registered employee.
Okay, we have a motion by Mr. Roberts. Do we have a second?
I'll second.
By Mr. Harvey to grant this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The company DD or whatever it is,
Certification number. Okay. I'm sorry, I don't call them back and say, hey, send me another letter after you put your,
Do we, I mean, are we issuing, or starting complaints on all those? And when, some of these where they're already involved in something, I mean, is it something that we could send just a letter of warning? Open a complaint on them?
we
or-
generally open a complaint, let them respond. And you were here anonymously. And you can decide if you want to send them a letter of warning or.
Would it be appropriate? I mean, is it something that we could send a letter of warning and
Not set it up as a complaint? That's a legal question.
that would save a lot of people a lot of work, but
You used to make a motion to automatically send them a $100 civil penalty, set it up a complaint and automatically send them a civil penalty, but we haven't done that in quite some time.
send them like a letter of instruction, aren't we, Josh?
And
First
been-
offense,
yeah, I think we've been doing letters of warning
or
on
first
those.
offense, I think. And then it goes up from there. But if you
Right.
don't if you don't open a complaint, you don't have a record of whether it's first
Yeah,
offense
and the
or.
only issue I see with it
not.
is the fact that it's not anonymous. I mean, when you guys see, if we did it the way that Mr. Cockcroft is suggesting, and just go ahead and send the letter of warning now, I think it, it wouldn't be presented anonymously because you have the respondent's name right there. I mean, we get several of these per meeting, and we could group them all together and say, these are all the people, that we open complaints against for failing to put their certification on their letterhead. And if it's all first-time offenders, that type of thing, then we could just do a blanket motion for recommending letters of warning be sent to all of them.
I don't
Yes.
have a problem with that. They just need to come into compliance like everybody else.
and I hate for us to be issuing a consent order or something where we're going to be more than if they hadn't even responded. I mean, the fact that he sent, they're attempting to respond to us, and I mean, if they hadn't responded, we might be issuing the same consent order or the dollar amount as not having your license number on there. I didn't mean to open a whole nother can of worms with that.
Are y'all ready for the next exhibit, or are we?
Yeah, we can move.
Right.
We're going to Exhibit K6. File number 30940. We have a 2004 charge in Collierville, 2006 Collierville, 2008 charge was dismissed, and another 2004 charge in Collierville. He did disclose all of these. There is a letter in the back from his qualifying agent that does have the certification number on the letter.
Madam Chairman, I make a motion we grant this application for an employee registration.
Okay. We have a motion to grant. Do we have a second?
Second.
And a second. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
The next exhibit is K8. I took K7 out late yesterday afternoon because there was expungement orders in there, so we're moving to K8, file number 28112. These are a little bit more recent charges, 2008 and 2011 and 2006. 2007 charges in Nashville did result in a conviction. I actually considered just suggesting that he come in today, but y'all can make that.
Madam Chairman, I make a motion we deny this application for registration based on prima facie evidence of lack of moral character, good moral character.
Okay. We have a motion by Mr. Roberts to deny this employee registration application. Do we have a second?
Second.
A second by Mr. Harvey and Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Next item on your agenda is K9, file number 30202. This one may take a few minutes to review. There's a number of charges that
know if he has an actual driver's license now?
No?
October 13, he was caught driving on suspended or revoked. If I'm reading that right.
And we don't really, unless y'all tell us to ask for a copy of a valid driver's license.
As in the letter from the, I guess it's the qualifying agent, asking us to reconsider, is,
His original application was denied based on a material misstatement because he did not disclose everything. We have a lot of those.
We'll make a motion to deny for discussion purposes. That most of these charges are older, which we would tend to negate because of age, but there's so many of them with one current. Is this somebody we might want to talk to in person? Or
I think that's reasonable.
We have a motion, but we didn't have a second, so.
I'll second with further discussion. Not driving on suspended or
So-
revoked.
so what would we do? Request the, I mean, can we
Appearance.
request an appearance versus just denying it? And then,
But it gives them a chance to come
Right.
in and explain if there is one.
Generally, when you do that, we invite them to appear with their designated qualifying agent, and we would schedule an appearance. So,
want to amend the original motion or just vote it down?
Let's just table that and give and invite the applicant with his qualified agent to appear before the board. And so I make a motion then to table this until such time as we've had an opportunity to invite him to appear before the board, and in the event that they choose not to appear, then we would bring that up and
Take appropriate action.
take appropriate action. So I motion to table this until we invite the applicant to appear before the board.
do we need a second on your
we
motion
have
to
Vote Keith's
table?
motion and my second
No, we
down first.
tabled-
No.
We
Okay.
tabled it. So we have a motion by Mr. Roberts and a second by Mr. Harvey to
table.
table the vote on the denial or the approval, but to invite this applicant and his DQA to come in and make an appearance before the board for further explanation on some of these past.
I'd like to include with that we invite them to appear at the next board meeting, and that we should bring this back up at the next board meeting.
So inclusive for the next
So
board
that,
meeting for the
because,
motion.
yeah, that'll give because it's gonna be several months off, that'll give them plenty of time to appear, and if they don't, we'll bring that back up. If they don't appear, then we'll go ahead and bring it off the table and vote it tonight.
That brings up a question. Do you want to schedule board business following the rulemaking hearing in October?
I don't know if that would give them enough time, do you think, or just schedule it for December?
I just schedule it for our next regular
As
meeting.
far as
That'd be
this is
December.
concerned, but we'll talk about the
Okay.
other a little bit
At
later.
the next meeting, I'll
Okay,
just
we have
put
a
next
motion and a
regular meeting.
second, pending on this. All in favor, voice by saying aye.
Aye.
All opposed? So we're tabling and then inviting them back to the December meeting.
Next item on your agenda is Exhibit K10. File number 31111. Thousand and seven. And a 2013. The 2013 apparently has been expunged.
Madam Chairman, I make a motion we grant this application to registered employee.
We have a motion by Mr. Roberts. Do we have a second?
I'll second.
Second by Ms. Jones to grant this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Next item on your agenda is K11. File number 31653. Individual, there are so many records to review. This one might take a few minutes. It was 2004. Got 2 years of probation, but there were several charges listed. Possession of schedule, I can't read what the number is. 4. Had cocaine and marijuana, so. Also a 2013 charge in Anderson County. Needed anger management for that. It appears they dismissed it upon completion of the anger management. So I have a copy of that in your.
Not a letter from the QA on this one, or not?
Sometimes they send it, sometimes they don't.
Madam Chairman, I'd like to have this applicant appear before the board.
Okay.
This is a very mixed record.
We have a motion by Mr. Roberts to request this applicant to make an appearance before the board. Do we have a second?
Second.
Second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries to have this applicant appear.
Next item. All right, we just like 2 or 3 more. I thought we'd finish this. I need to speak with her before the appearance. Exhibit K12, file number 30512. This individual has a 1995 conviction, and that's all, for petty larceny in Arundecoit, New York. There is a letter from her qualifying agent. It's not on company letterhead, but it does have the certification number on it. And it's the correct certification number.
And he identifies the company too, so. Okay.
Make a motion, we accept Ms. Vaccaro's registration for alarm employee.
Second.
Okay, we have a motion and a second to approve this applicant's for employee registration. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Exhibit K13, file number 30504. This one has current charges, it's 2013. Quite a bit of paperwork for this one charge. There is a letter from the qualifying agent.
No, you can discuss it.
I mean, it's awful recent. From the explanation, it almost seems so out of character that's the only thing he's got on his record, but it.
He was born in 1992, so he's. It says the actual
say
cost
on
of the
either Harmony?
merchandise was $38.40.
Says it was damaged. Does that mean he damaged it trying to hide it, or it was damaged in the exchange?
I think the damage is what they just charged him as a fine. I don't know.
Madam Chairman, I make a motion we invite this applicant to appear before the board so we can further evaluate the situation before we either grant or deny his particular application.
Okay, we have a motion by Mr. Robertson, second by Ms. Jones to request this applicant appear before the board before taking any action. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Last exhibit in item K is K14, file number 29851. There's a 1993 issue in Sullivan County, Tennessee, and a 2001. This one has an unusual explanation. Charges, I believe, were felonies. Or at least one of them was.
Letter from the QA with this.
I don't see that either.
No, I asked for one. He
Yeah.
sent one on one of the previous applicants, but I don't have anything. On the application, if you disclose anything to send court records, and if there is a conviction, we would like a letter from your qualifying agent.
Motion to accept Mr. White's employee alarm application.
Mr. Harvey to grant the employee application. Have a second.
Second.
We have a motion and a second to grant this registered employee application. All in favor, voice by saying aye.
Aye.
Aye. All opposed? You want to vote?
That a yes vote? Okay.
I think that's the end of those,
That
correct?
concludes this portion of the administrative report. I would like to request just a really short break while I speak with this applicant.
Take 15 minutes to give her ample time to talk.
Okay, we're gonna call it back to order. The next item on your agendas is Exhibit I. It's an appearance. Tony McCants. Ms. Stubblefield came in the office and requested that she and this applicant appear because she didn't want to put her to work until y'all had reviewed her record. So I'll give you a chance to look over Exhibit I. I think there's quite a few pages of the information from Florida. I've been trying to fix it. I haven't nothing for shit for damn years.
It has been paid in full.
I didn't even know there was a
Yeah,
balance.
let's get the microphones where everybody can hear if y'all are.
We just asked her about, did she have a balance due?
On some
I
court
know, but
fines.
again, it
Okay.
needs to be on the record, so. Sorry.
It's a little confusing on this one document. I think it looks like it shows a balance due on 9/10, but that must not be right.
As in your paperwork show I don't remember the amount, what was it?
640, hold on,
644.
644.45.
It was
Not all
paid.
these other credits and things down here, it may just be the way their system.
There is a receipt for a recent payment. I didn't know that there was a balance on this.
Have to-
I did pay it recently.
Okay.
Yes, ma'am.
You submit the receipt to the state?
Yes, ma'am, I did.
Beth, will you look in your folder and see if you find a receipt for paid in full on the, so you do have it?
I didn't realize, I thought it was a receipt for fingerprintings.
That's okay.
Sorry. Advanced Financial, hold on. Orange County Clerk's Office, 644.55. Fee was $9.95, and it's dated September 9th. Oh,
So according to this, your arrest was in 1993, and you've not had any other arrest since 1993?
No, ma'am, I have not.
Is this a fine left over from 93 that you just didn't pay? Didn't?
I actually didn't even know that I had a fine. I was 17 at the time.
It shows receipts in 09 and 94, and it shows you've been paying on it.
I
But-
never made a payment on it. It's something that says per conversation, so I guess there was some deductions made from the court system. I didn't know about the balance at all.
Version. What's that mean? Miss Lawyer.
Conversion adjustment.
Okay.
I guess they reduced it down some. How long has Ms. McCants worked for you? She's not worked in any capacity
Because
yet?
knowing in advance, and she has been very forthcoming, knowing that this was on there, then I wanted to be sure that she had the approval of the board before I brought her on board. Working with me as my assistant and also as customer care, and I wanted to be sure that she was okay with the board before we commenced our relationship. So I appreciate that.
Y'all have any questions for either of these ladies?
Why don't you give us a narrative of
Explanation.
explanation of what's occurred and what's happened since then?
Okay. I actually was in college, my first year of college. I left Orlando. As you see in my story, I left Orlando to go to college. And my first year, I came home for the summer. My sister, who's older than me, 2 years older than me, invited me on a trip for her graduation present from her boyfriend. And it was to Jamaica. And again, I was 17 at the time, trusting my sister, thinking that we're going on a vacation and I'm coming back to go continue my education in Jacksonville in summer school. I got there and We were pretty much locked up in a house, can't go anywhere. Just there until it was, the time was, I guess, up and time for us to go back. And it was time for me to go back to college. So I was waking up one morning and said my suitcase was ready and it was time for me to go. And I was ready to go. It was time for me to go home. I missed my family.
You were locked up, you were just there. I mean, you went to Jamaica for
We went
a vacation. I don't understand what got
we
you
were
locked up.
at a house. I was there with my sister and people that I didn't know.
They wouldn't let you leave.
No, there was no communication with my family other than my sister that was there. 2 different people, 2 different lifestyles.
So the people in Jamaica were, the only family member there, if I understand, was your sister.
My sister had friends. Well, her boyfriend was giving her the trip to Jamaica for her birthday. I didn't know any of the people at all. I was just coming home for the summer and invited to the trip. So when we got to the airport, there were 2 other men that came, and they went with us to Jamaica. They had the establishment for us to stay in, but we weren't allowed to go anywhere. Something I've been going throughout my life. Therefore, I trusted her to go to this trip. When it was time to come back and I came back to the United States, there was a marijuana line in my suitcase that I knew nothing about. I came back by myself, so I didn't say anything to anyone or the authorities because my sister was still in Jamaica and they knew where my family lived, and I didn't know how ruthless these people are to do such a thing. So I took the charges. I returned to school. I got kicked out. I lost my scholarship. And I'm just working, trying to make a living to provide for my son. And I want to be a part of this company and do what I can to better my life, make a career, contribute to the society and the community in which I live. And that's pretty much it. I was in the care the one time. I would say the one time I stopped being a leader and decided to be a follower. This is what happened.
So you were 17 at the time. Why did they charge you as an adult, I guess, is the...
Because my birthday was shortly after.
Probably transferred it to adult court. Okay. Questions?
We apologize for, or I apologize for putting you through what's obviously a traumatic experience for you, but you can understand that we have the unpleasant job sometimes of making a judgment call, and we try and understand the circumstances and what has gone on and what is going on, and you may have heard me say a little while ago, sometimes we have to make some tough calls. And so, again, I'm sorry you went through, were put through what was a repeat of a traumatic experience, but I appreciate your forthright explanation of the circumstances, and that's a big help to us to make a decision. Thank you. And this is an application for a registered employee.
Yes, sir.
You obviously feel comfortable employing her.
I'm well aware that prior to the time that she had even, if her life had been anything other than excellent, then she would not have been able to achieve the scholarship that she did from the Disney people. Her life since then has been excellent. All the references that I have checked have been excellent. We have a mutual friend that I took aside, and I said, give me the background scoop here. Everything has been absolutely stellar. And so in my mind, this is something that happened 20 years ago that she had very little control over. And I'm perfectly comfortable with her working with me in the office. Yes, sir.
Ms. McCannis, what sort of work have you been doing? You know, there's a significant period of time that has elapsed there. You've been working, doing other things?
Yes, sir. I've been a property manager. I've been a human resource manager for a manufacturing company in South Florida. I've been an eye doctor assistant, so I've had pretty good jobs. I've been managers of 9 West and Company for quite a few years. I have an extensive background in management.
Madam Chairman, I make a motion that we grant this application for registered employee.
I'll second.
We have a motion and a second to grant your application for registered employee. All in favor, voice by saying aye.
Aye.
Aye. All opposed? Congratulations and thank you.
I appreciate the opportunity and thanks for the consideration.
Thank you very much.
Sign anything? You can sign the sign-in sheet that you were here if you haven't, please, just so I have a record of your being
Yes,
here.
ma'am.
It'll still take us a couple of days to get this process approved. Okay.
Actually, okay, I mean, she could start working, could have been
She
working
could have
anyway.
been working for 30 days,
Right.
and this, again, we have everything we need to get it approved. I don't know that it'll get approved today, it might be tomorrow, I bet.
Yes, sir. She both wanted to be very careful that she didn't have a lapse in the income. That we had any issues, so I appreciate your time.
Thank you for coming in.
The next item we have on the agenda is the education report. We only had 3 courses today, as opposed to last meeting when we had 3 pages of courses.
What?
The first item on the report is called Minuteman UPS AMG Uninterruptible Power Supplies 101. It's a 2-hour continuing education course. Keith reviewed it.
I think it's great for 2 hours CEUs. That's more than ample.
Okay. The next item was the Minuteman UPS/AMG Avalon Wireless. It's a 2-hour continuing education course. Scott Cockcroft reviewed that one.
Is that the title, the Minuteman UPS?
That's the
other-
provider,
Oh, okay,
AMG.
okay.
I think they've changed their name. It's called Avalon Wireless.
The class it was definitely very comprehensive, and it was definitely good for 2 hours. There's a lot of content.
Okay. The next item was submitted by Jade Learning. Ken Roberts reviewed that. It's an online course called Network and Cabling for Security Installations. They're asking for 4 hours.
That's a continuing education, is it not?
Yes.
Yeah, I think it's a reasonable online learning course for 4 hours. I would recommend that we grant that particular course.
The recommendation for all 3 is approval as submitted. Do we need a motion?
Make a motion that we approve these 3 courses as they've been submitted for continuing education.
Okay. We have a
Second.
motion and a second. All in favor, voice by saying aye.
Aye.
All opposed?
Motion in that.
I had one
Scott.
from Keith and Scott.
Well, that's
so-
why I was confused.
Oh, I didn't hear Keith.
Who do we pick? Scott, he raised his hand.
That's why I
That's
didn't
good.
say,
Oh,
because I heard them both. It was like stereo.
Well, that's why I thought I heard the same thing.
Yeah.
So, the next thing on the agenda is unfinished business.
It shows criminal history approval authorization, Exhibit M.
We did put an item under there. There could be other unfinished business, but there is one item y'all need to review. It's Exhibit M. About 2 years ago, at a meeting with Mr. Simpson was our staff attorney, the board agreed to have a list of convictions that a certain amount of time had passed that may be listed in the statute, but that were approvable in-house. And Mr. Simpson was asked to provide a list of those charges, and that's been 2 years. So we kind of got together this week, and I drafted this list of charges, just to give us, the whole purpose of this is to, I'll read this. It's to authorize Cody to be able to approve these, some of those that you looked at today that have a 20-year-old possession conviction for, that doesn't need to be on the agenda. It's really increasing our workload and yours too. So to increase board meeting efficiency, as well as to reduce board meeting business. Anything outside of the scope of this authorization would obviously be brought to the board. But if you would look over the list of these that we drafted, I have the attorneys review them. There could be other charges that really could go on here. But your statute specifically mentions possession and theft.
Charges pending would include probation, or like on one we had where somebody was.
Yeah, if they have pending charges or they're currently on probation, this is and again, I use the 10-year term, okay? So if they've had any conviction in less than 10 years, it would still be presented. You could make that 5 years if you want to, but I had to have a starting place to kind of get an idea. But I think most of the ones we looked at today, like the petty theft in 1995 and the possession in 1993, other than felony possession, this is all misdemeanor. But read over it. You don't have to approve it, but it would certainly assist us in the office.
Felony stuff would still come.
Read the whole thing and then we'll talk. Again, I don't know that I worded it right legally, but
Pretty simple. It looks straightforward.
Basically, I would understand it as it would come before the board if they have any pending charges.
if they have any
If
other
the-
charges,
Yeah, any pending charges or any, I guess, where they're,
recent convictions,
or any felony at any time,
yeah.
or any misdemeanor that we've got listed here, which is basically controlled substances or theft or bad check or something like that within the last 10 years.
Right,
Any of those circumstances be brought before the board.
any of those. And I think the biggest, and the only thing we listed as far as possession was simple possession. If it's possession for resale, that's a whole different matter. And if it's cocaine for resale, that's a whole different matter. So, but it would have eliminated probably 5 of these files today that you're gonna approve anyway. So,
It looks pretty reasonable to me, frankly. Let you deal with some of these cases administratively.
and if it's anything outside the scope of this list of charges at all, it's still gonna come to the board. And Cody does
Or if
have
it's
the
anything
authority
or
to
anything
deny an application based on their criminal history anyway, so that would be probably an appeal. So,
Or anything within the last 10 years.
I remember Andrew talking about this.
you guys basically approved it,
Yeah.
we just never gave you the list of the charges and the time frame.
I think
We
it
never-
looks pretty reasonable. What do the rest of you think?
Yeah, I agree.
Scott, what do you think?
Yeah, it looks good to me. It makes sense. I
And
mean,
answers
there's
the
no,
question you had earlier. You was wondering on why we were going back so far.
Madam Chairman, I make a motion that we approve this as a policy.
It can't be a policy, it's an authorization.
Okay.
Sorry, I didn't mean to interrupt.
That's
That's
better, we
fine.
can change it now than
Yeah.
unvote it.
Isn't
Do
it,
a-
we make the, well, to me,
We authorize
we,
Cody
it's
to
a policy
use-
that we authorize Cody to do this, but,
Right.
yeah. So,
So what are we doing? What are we?
Madam Chairman,
What
I
are we
make,
calling it?
I make a motion, we,
Authorization.
We're authorizing Cody to use these as guidelines when reviewing criminal history on applicants.
Madam Chairman, I make a motion that we adopt this statement as it is presented here, which is to authorize Cody to approve employee registrations and QA applications within the criteria here.
Okay, we have a motion by Mr. Roberts to approve this document as presented. Do we have a second?
Second.
We have a second by Ms.
Everybody did.
Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. What else we got?
I don't know if there's any other unfinished business or any new business that we don't.
Anybody got anything else they need to discuss while we're here? We'll be back in, yeah, that's something we need to
That is
discuss.
something we need to discuss on our
On
new
the
business.
October, you want to have a short board meeting the day after the rules making? Is it what you were saying?
No, I think you could do it that afternoon. The
afternoon?
rulemaking hearing is at 9.
Yeah. I don't have any idea how that's the process, I guess.
Generally, for the number of rules that you have, unless there's an amazing amount of public comment, Mr. Scudder or whoever's administering the rulemaking actually has to read each rule into the record. There's a time for comments. Written comments are read into the record. But I don't believe it'll last more than probably about half a day. We
Do
could
we
actually,
vote on these after,
at the rulemaking hearing,
Yeah.
yes.
I mean, we do.
Yeah, we vote
I don't
at
think
the-
I've ever gone through one.
We
since I
vote
was
at the
asked.
rulemaking hearing. Yeah.
Right.
Okay.
And you know, again, there may be, it could be 1 o'clock or 2 o'clock. I wouldn't schedule any appearances, but if we can get some criminal history files, or are there any courses, do you want to convene a regular board meeting immediately following just for an hour or two to?
After maybe an hour, because we're gonna be in from 9 to 1,
Whatever.
and then, but I think we can all agree that we would have a short board meeting that same afternoon as the day of the rules making hearing. Is that agreeable with y'all? Okay.
Deal with any,
Any courses, I mean, again, if there's some reason, there's not gonna be any appearances, if there's some reason you didn't have time, we would just put it on the December meeting.
Have time to do, you have to do notice or something of that, or?
It's already been, the notice is already out because of the rulemaking hearing.
Right.
And I believe when I posted it on the website, I put rulemaking hearing board meeting, just to make sure we were covered.
Need to vote on that, or it's just, you wanna
let's
vote?
just do it.
Let's just do
I
it.
don't know, we need to vote on it.
She's already put the notice out there, so we'll
Well,
just do
again,
it.
a rulemaking hearing is actually a board meeting, so, but
Right.
we just wanted permission to kind of add some stuff, if we could
Certainly.
get some stuff ready to get it moved on. So like, I don't know if we'll have a complaint review.
We aim to please, so.
Thank you. But that's all I had. That
Okay, anything else? All minds clear? Anybody in the audience got anything to say? It's your last chance. This meeting's dismissed.
Yeah.
Thank you.